Good morning, everyone. I'm Karine Coutinho. I'm the VP Marketing and Strategic Alliances at Lemonway, and I'm really glad to have you online today for this new webinar. And the topic of today, as you know, is the new European crowdfunding regulation, the so-called ECSP. As you know, 1 year ago, the regulation on European crowdfunding service providers for business was published. And as of November the 10th of this year, platforms must take all the necessary steps to obtain ECSP status before November 2022, or maybe not, if there's an extension period. It's a teaser on your presentation, Sophia. So to decode this new regulation and make sure that it's clearer for all of you online, we invited 3 experts. And their mission, if they accept it, is to make sure that you have as many takeaways as possible to get prepared to what's coming. So I'm very happy to welcome my colleague, Sophia. She's actually a senior compliance expert at Lemonway. Really glad to have her online. She will perform a kind of regulatory scan, and she will take us through what it takes to get the ECSP status. And then we'll have a super interesting open roundtable discussion with Johannes. Johannes is based in Germany. He is counsel financial regulation at Bird & Bird. As you probably know, Bird & Bird is the international leading law firm in business sectors dealing with technology. And Javier is co-founder and lawyer at CISAE. CISAE is a Spanish law firm specialized in fintech. And within the firm, Javier has a specific focus and expertise on crowdfunding business-related matters. So in a few words, we're in very good company this morning. Just before we kick off the session with Sophia, let me share a couple of housekeeping remarks with you. This is an interactive session, right? So feel free to interact with us all along the webinar. You have a panel on the right-hand side of your screen, a tab called Questions. So feel free to insert your questions in there. I will pick them up during the roundtable discussion. We'll have a bit of time to take some of them. I see participants still joining in, but let's kick off the session without any further ado. So, Sophia, the floor is yours.
Hi, everyone. Thank you for joining us for this very new topic, European crowdfunding regulation. We're gonna try to go through the regulation and what changes, and especially the regulatory scope of this new European crowdfunding regulation. So now, what changes? What is the current approach? Basically, in Europe, crowdfunding platforms are regulated through national law. There is a wide range from no regulation. For example, in Italy, most of the crowdfunding platforms do not have to seek authorization. To very strict rules. You do have very strict rules in many countries, especially, for example, in France or other countries like Germany and Spain. Now, there is a lack of mutual recognition between EU countries, which means that if you are a platform in France and you want to provide your services in another EU countries, you can't do it. You can't passport your services to another EU member state. Therefore, you will have to be registered to, for example, if you want to passport in Spain, you will have to set up a subsidiary and then register through the CNM MOVE, which is the local regulator. Now, what is the implication of such a wide range of regulation? It means that you do have a concentration of some crowdfunding platform businesses in certain jurisdictions, and especially in jurisdictions where it's not regulated, as it is easy to go live. Now, the new approach of this European crowdfunding regulation changes a lot. What does it do? Basically, if you're an authorized crowdfunding platform in one of the EU member states, you will be able to passport your services through other countries of the EU member states. Meaning that if you're a crowdfunding service provider in France and you want to passport your services in Germany, you will be able to do it, and we will see that in the further slides. Now, when does it start? Basically, from the 10th of November 2021, it's the actually enforcement date, and you have a transition period to the 10th of November 2022. Now, the European Commission can extend this transition period to the end of 2023, but for now, let's say that every crowdfunding platform which falls within the scope of this new regulation will have to be regulated, will have to seek authorization by the end of 2022. Now, not every crowdfunding platform is concerned by the scope of European crowdfunding regulation. It will be only the scope of this regulation will be only for crowd lending and crowd equity. Now, so the applicability, basically, the instrument would be loans or placing of equity of debt, which is basically what crowd lending and crowd equity does. The project offers can be up to 5 million only. This 5 million is counted by year and per project. Now, the project should involve only business activity, which means that project holders who are consumer are excluded from the scope of this regulation. And it excludes, obviously, crowdfunding platform, which are donation, because it's only for crowd lending and crowd equity, which means that there is an investment and a return of investment. Now, there is, regarding the timeline, the regulations says that obviously, as I said, there is a 1-year transition with the possibility to be extended, as we have said, but let's say that crowdfunding platforms should be able to submit their application by the end of 2022. Now, the regulation is quite clear regarding the timeline that the competent authority can take to assess the application. Now, the regulation says that the platform should submit its application to the authority, and within the 25 days after the submission, the authority should check if the application is complete and then give the receipt to the platform saying, okay, the application is quite complete. And then within this receipt, the competent authority has 3 months to analyze the application and gives its approval or its refusal. This is written in the regulation, but we know now that we've talked to many regulators that it won't take only like 4 months. It will probably take more regarding, and I mean, we have to assess that there will be a lot of workload, as a lot of crowdfunding platform will have to seek the authorization, and it will take, we think, at least 6 months to be regulated. Now, the status of those crowdfunding service provider. So, as we have said, it will be mandatory for platforms, crowd lending platforms, crowd equity platforms, that falls within the scope of the regulation to seek the authorization. It will allow the operation in every EU member state without the need for additional authorization, meaning that you don't have to go to Spain and go to the local regulator, which is the CNMV, or to Germany and go to BaFin and ask for another authorization. Now, this status does not allow crowd investment platforms to advise on investment. They will have to combine their crowdfunding platform with another status, which could be the status of investment firm, and it depends on the local law. Now, in France, we do have two regimes. It's called IFP, Intermédiaire en Financement Participatif, or CIP, which is Conseiller en Investissement Participatif, which will be replaced for the crowdfunding platform that falls within the scope of the new regulation. Now, if you want to passport, how can you do it? Basically, step 1, you are authorized as a crowdfunding service provider. Step 2, you inform the competent authority. Like, for example, in France, it will be the AMF. You inform the AMF that you want to provide your services in Italy, for example. Then the AMF has to so it's actually the regulator who is going to contact the host member states, which is, for example, in Italy, I think it's Banco d'Italia, and inform the host member state that that this platform will passport. Now, the crowdfunding service provider is allowed then to provide services from the date of the receipt of the confirmation by the home member, by the home authority, which will be the AMF. So it will be easier to passport your services. Now, there is quite quite few changes now to the to this crowdfunding platform, meaning that they will have to assess if an investor is unsophisticated or sophisticated, which is part of the will of the European Commission to protect investor. Now, the unsophisticated, how will they do it? There will be a knowledge test. The crowdfunding platform will have to provide a knowledge test to assess if it's an unsophisticated investor, meaning that it does not have enough financial information or skills as per the knowledge test. Then the unsophisticated investor should not be able to finance a project in excess of €1,000 or 5% of the net assets. Now, if they still want to do it, it's not it's not completely forbidden. If they still want to do it, they will have to accept the risk incurred, meaning that they'll have a disclaimer, they will have to formally accept the risk, and then after that, they will be able to invest more than €1,000. Now, if it's a sophisticated investor, they will be able to invest without any limited amount. Now, there will be other changes, other operational requirements. There will be a cooling off period, which means that normally, if you're an unsophisticated investor, you will have 4 days to withdraw your investment offer or interest in the crowdfunding offer. You don't have to provide a reason to withdraw your investment, and the crowdfunding platform cannot associate a penalty to your withdrawing. Now, the crowdfunding platform is not subject to the AML, not for now, but they will have to provide due diligence, perform due diligence on the project owner. They will have to verify, for example, if there is a criminal penalty involved, if the project owner is from a country of a country deemed high risk or non-cooperating region. As I said before, there is a lot of emphasis on investor protection. Therefore, marketing communication is quite important. And the crowdfunding platform must communicate in a fair, clear, and not misleading way. It shall be consistent with the information contained in the knowledge test. So basically, the marketing communication has to be thorough. You have to think about your marketing communication. You have to make sure that everything regarding the project is written in the marketing communication. You have to make sure that you do not disproportionately target planned, pending, or current individual crowdfunding projects or offers. As we have said before, there is a single threshold, which is 5 million per project and per year. And this offer cannot exceed this threshold, otherwise it will be regulated under another regulation, which is MiFID II. Now, two very key points. For now, the regulation does not subject the crowdfunding platform to AML. Right now, the European Commission will assess the necessity and proportionality of subjecting those kind of platform to the obligation to comply with the AML. So for now, there is not a lot of information regarding AML and everything that goes beyond the regulation. We will have more information in the upcoming months. But for now, it's not in the regulation. Now, something that it's written actually in the regulation is payment services. So a crowdfunding service provider does not entail that a crowdfunding service provider authorization does not entail that you can provide payment services. If you collect funds from a third party to transfer it to another third party, then you provide payment services. The regulations say that you need to be a PSP, meaning a payment service provider. So it can be a payment institution or otherwise, or you need to process, or a payment service provider must process your payment services. There is quite few ways to associate yourself with a payment service provider. You can be payment agent or you can be a partner. If you're a partner, you cannot collect the funds of the investor to transfer it to the project owner. We can go deeper afterwards regarding this. Now, let's have a use case just in order for you to understand how it will work and how you can passport and the transition period as well as the end of this transition period. So let's say that the 10th of November of this year is the beginning of the transition period. Now, you are a very thorough platform and you submit your application on the day of the beginning of this transition period, the 10th of November 2021, which is quite unlikely, but let's say you can do it. Now, the IMF confirmed that the completeness of the application of the ECSP platform. The IMF validates the ECSP registration of the platform. Now, you have the end of the transition by the end of 2022. And then if you want to provide your services, you inform the IMF of your intention to passport. The IMF contacts the BaFin, let's say that you want to passport in Germany. And then the platform receives the receipt of confirmation from the IMF, and then you can go live in Germany. Now, as we have said before, there is a lot that the regulation doesn't say, and there is a lot that the regulations say. We give the ESMA and the EBA the delegation power to deal with that kind of matter. So we call it the regulatory technical standards, which are regulatory technical standards that will give more information on a few matters, like, for example, complaints handling, conflict of interest authorization, more information on the authorization. So we are waiting from the EBA and the ESMA a lot of further information. Now, the new crowdfunding framework is not quite complete, and we have talked to many regulators who have told us that they actually don't know yet how they will regulate crowdfunding platform, and we will have more information, I think, in the upcoming days. Now, there will be more stringent local regulation that may still apply, especially in specific area regarding, for example, marketing communication. We do know that in some EU countries there is more stringent local regulation, and they will still apply. We will still be waiting the technical standards to have more information, and especially regarding the regulatory reporting, for example. Now, the key takeaways, as we said, to finish this presentation, there will be a new harmonized EU legal framework for crowdlending and crowd equity platform, or for offers up to 5 million euros. The project holders must be business activity. A crowdfunding service provider will be able to passport its services in all EU countries. The new framework will include investor protection, cooling off period, and other protection regarding the person who will invest. The enforcement date will be from the 10th of November 2021, with the extension possibly to 2023. But normally, a CSP, a crowdfunding service provider, should be able to submit an application by the end of 2022. That's it for me.
Thank you very much, Sophia. Great insights and great takeaways. Before we move on to the roundtable discussion, we received a couple of questions and requests for fine-tuning information. Maybe I can start with this one that you see appearing on the screen. What is the situation for crowdsourced donation platform? Is the onus on the firm to prove its donation actually, and not crowdlending or crowd equity? It's a self-assessment or something like that? How do you need to prove the activity to make sure that you don't fall under the regulation? We don't hear you. You're on mute. Sorry.
Sorry, can you repeat the question?
Yeah. So you don't see it on the screen?
I'm trying to find it. There is a lot of question.
Yeah. It's about the
yes.
Yeah.
What is the situation of crowdsourced donation platform? Is the onus on the firm to prove that it's donation only and not lending finance, or do you self-attest or similar? Well, to be fair, normally you should prove that it's only donation, but if you don't submit the application and if you don't submit the application and you know that you're not within the scope of the regulation, I believe that until the regulator comes and say, okay, now you need to apply, I think you're okay, but you definitely need to go to the regulator and ask. I think that you should start a very open conversation with the regulator. And I'm saying that to every crowdfunding platform. Normally the regulation is for crowd lending and crowd equity. If you're doing donation, then you're not within the scope of this. Now, if you're between crowd lending, crowd equity, and you don't really know if the regulation applies to you, I think that it's very important now to have an open discussion with the regulator in order to understand if you have to go through the authorization or not.
Thank you, Sophia. And there's another question regarding the thresholds. Can you see it on the screen? The new regulation applies, it says that the new regulation applies to those who manage up to 5 million or more than 5 million.
It's up to 5 million.
Yeah, if you can. Yeah, okay. Thanks for the clarification. And another question, don't know if you can see it on the screen either.
Could you please clarify? Yeah. About the order of interaction between the content regulators of the member state within the transition period, especially in case if a jurisdiction has not adopted the special crowdfunding regulation and not implemented the regulation presently. The order of interaction between the content regulators. So basically, it's a regulation instead of directive. It doesn't have to be transposed. So from the 10th of November 2021, it will enter into force in all EU member states. So even if your regulator, I don't know where you're from and which regulator is yours, but even if the regulator hasn't actually communicated about this new regulation, it should apply to you. So again, I assume that you should definitely start to contact your regulator and ask about it. But normally, I know that a lot of regulators in EU member states doesn't know yet and haven't communicated about it. But you should definitely start to contact them.
Thank you. And the last one before we move on to the roundtable.
Yes, if an existing platform operating outside the EU would like to make use of the new regulatory framework, would it be required to create a new legal entity within the EU to operate the platform, or would it be able to apply as a non-EU operator of a platform? So normally, and I believe that a lot of crowdfunding platform in the US will come and to seek authorization. You have to be registered in the EU. You can't come from another, or I believe you might ask for the UK platform too. Normally, you have to be registered in a EU member state, and from this EU member state, you can passport.
Thank you very much, Sophia. A last one, and then we move on because we see lots of questions appearing, meaning that the topic is hot.
Yes. What are the changes for real estate lending platforms? Well, real estate lending platforms are most of them are crowd investing, crowd lending. So basically, they should fall within the scope of this new regulation. Now, I know that a lot of crowd lending platform, and especially in real estate, are in Italy. And I believe that they definitely should contact the Banco d'Italia, and I think that they might fall within the scope of this regulation. Yes.
Brilliant. Thank you very much, Sophia. So now curious about having Johannes and Javier's views on what is happening in their region. So the first question that I would have for you both, Johannes, Javier, is after Sophia's introduction to this ECSP regulation, can you share insights on how this new regulation scope is embraced locally by your regulators? Maybe we can start with Johannes in Germany, and then we can follow up with Javier in Spain.
Yes, thanks for the introduction, Karin, and thanks for the wonderful presentation, Sophia. That's a really good starting point for the discussions and also the questions we already received here and you discussed. From Germany, we have already passed a law which is accompanying the crowdfunding regulation. So, for example, introducing that our regulator BaFin will be the competent authority to handle all the license applications in Germany, and also to act on the question which instruments are admitted for crowdfunding other than securities and loans. However, from BaFin itself, there's a kind of silence, so there's no official publication. They have not issued any guidelines. I guess this is connected to the fact that the technical standards from ESMA have not yet been finally passed, but are only due to be submitted to the Commission on 10th of November or even later. And therefore we are just working with the accompanying law and the regulation itself together with the consolidated technical standards.
Thank you, Johannes. Javier?
Hi, Karin. Well, first of all, thank you for the invitation too. It's been great, the presentation. And we are in a similar situation as in Germany. I think that all countries that we had already a specific regulation for crowdfunding, which is the case of Spain. In Spain, we had a specific law since 2015. And we are waiting for the guidelines of the ESMA. But like going further, like I don't know what's the attitude of the local national authority here regarding the new regulation. But I think it's pretty fine because lots of problems that we had in Spain with crowdfunding platforms were because they couldn't do some things that they will do now with the new European regulation. No? So I think that the how you say this, the attitude of the regulator before the new regulation is fine. Now we can invest through SPVs, that this was impossible here in Spain. The passport, of course, that's great. And I think also the fact that the Spanish regulator can see other interpretations of national regulators, and their interpretation is gonna come from the ESMA, probably. I think it's fine. So they don't have to say, okay, how do we interpret this part of the law? Like this or like this? They won't have this problem because there will be like an upper authority which will help them in this interpretation of the regulation.
Brilliant. Thank you. Sophia, do you want to elaborate on this? Or maybe we have a question from Abdullah who is asking, regarding UK crowdfunding platforms post-Brexit. I know that there's lots of questions around this. Do you have any insights to share?
Well, for now, as I said, we don't have a lot of insights, but if you are a UK registered crowdfunding platform and you want to come and get your crowdfunding service provider authorization in EU, I would suggest that you set up a subsidiary actually in one of EU member states, maybe one of EU member states that is known to have a quite efficient regulator, and then passport from there.
Thank you, Sophia. Next question is about the impact now on platforms from their standpoint, right? So there's a question from Torsten. It's actually quite related to the one I had in mind, so maybe we can start with this one. It's about Germany. So Germany seems to have adopted a very special liability format, which seems stricter than in other countries. Will this also be applied to platforms from other countries that passport their activities to Germany, or only to platforms that are initially licensed in Germany?
Yeah, I've heard that some lobbying groups in Germany say that the liability concept is too strict. However, from my impression, it's just the same which is applied to security prospectus as well. So what's the background? If you are issuing a prospectus, then of course the issuer becomes liable for any kind of mistakes in this prospectus. At the same time, those persons which take responsibility for the prospectus becomes liable. And this is in several cases also the management, so the director of the company which has issued the security. And the same approach is here taken for the information sheets. If you are the director of a German company issuing a crowdfunding instrument, and in the information sheet there is a mistake, then you might be liable with your private assets. This is a more or less general concept for prospective liability in Germany. And so on the question whether it applies only to German regulated platforms or German issuers, if I recall it correctly, the accompanying law makes reference to the regulation, which means it is not limited to those licensed in Germany, but applies to all which are offered to German customers.
Any other impact that you've seen in Germany for crowdfunding platforms?
Yes, so I think the most important impact is that we have now one license which you can obtain, and then you can provide crowdfunding. Until now, there were several models how you provide crowdfunding. So there was a possibility to get a license under the German trade regulation. There was also the possibility to obtain a MiFID license. Then you can of course act into more possibilities than only under the local license. And many of the German crowdfunding platforms act as tied agent to MiFID license institutions. And the first step when you want to start your business in Germany was to establish which is the right license format for you. And now with the new regulation, this step, more or less becomes redundant. You don't have to do that. You just can apply for one license, which gives you the chance to operate your business. I think that makes it easier to operate from Germany. I think other important change is, of course, the information sheet, which, however, is not nothing which is really totally new, because in Germany, all crowdfunding instruments are already connected to a prospectus or information sheet requirement. Here, however, you have the chance to get international with this sheet and are not linked or not bound by only local regulations. That makes it more convenient for crowdfunding platforms.
Brilliant. Thank you, Johannes. Do you see similar approach in Spain, Javier, or any specific impacts that you experienced?
I think that we have to distinguish first between the current crowdfunding platforms and the potential ones or the future ones. No? Like regarding the first ones, the current crowdfunding platforms, or the ones until the next 20 days, which they have one bad thing, that is that they will have to change, we don't know how much, but basically a big part of their compliance requirements, documentation, new obligations, like the MiFID implications for the testings of the investors, for example. But the good thing about those is that they are gonna have like a extra time because we don't have the guidelines. And at least what I've heard is that for new platforms, we are not gonna have the guidelines, and this is the new procedure until, I don't know, maybe 2 months, 3 months, 4 months, I don't know. So the good thing about the current crowdfunding platforms is that they are in a higher preference situation now. And the ones, like if some of the people that are listening now, they want to be a crowdfunding platform, it it's gonna be tough because of time. Like they're gonna be in a limbo. So I think that's something bad because, for example, in our case, we have two clients that they want to be a crowdfunding platform, and like we talk each month and to talk about the same thing. Like we have some news, we have the guidelines, and the answer is no, we don't have the guidelines. But in general, like taking both types of crowdfunding platforms, I think the impact is going to be like better as the situation we had before. I think that having like homogeneous communitary regulation is mostly always fine. The passporting part, I think, is key. And you said something at the beginning, I think it was Sofia, that now, before the entering into force of this new regulation, some countries had like more flexible regulations in crowdfunding because they didn't have a specific regulation, and some platforms went there. But I think that wasn't so good, because if they wanted to like focus the market, for example, in Spain, an Estonian company, if they want to focus in Spain, they have to comply with the Spanish regulation. So it wasn't so good, At least they had a bit of lack of legal certainty. So now this disappears, and we have like a more homogeneous regulation, more legal certainty.
Yes, and there is another thing. I'm going to add something that you to what you have just said. Now, the crowdfunding platform registered in countries where there is a regulated status will be more prepared, because they have already to comply with many with the regulation, with the regulated status, and they are already supervised. Talking to French, especially French crowdfunding platform, we do have regulation. You do have a regulated status, so it will be, I'm not going to say completely easier for you to comply with this new authorization, but at least you do have process, you do have implemented policies, you do have all those regulated obligations that you have had to comply with, and you don't go from scratch. You already have stuff in place.
Thank you all. There's another question that is coming to my mind listening to you, and it's perceived and related to the application of this regulation in the different countries and how it's interpreted. So to some extent, this regulation can be perceived maybe as anti-competitive. So do you think that some countries will benefit from this regulation more than others, and it might create a kind of new specific or new kind of competition? Do you think it's the case, or not at all? Maybe we can start with you, Javier.
Yeah, as I think it's a bit connected with what I was saying. I think that it can happen, of course, this anti-competitive fact, because of the interpretation of the law. Like even regulations, not just, directives, of course, they can be interpreted because you need a transposition. Regulations are like more strict, This is what it is, and it applies to everyone. But there's always a percentage part of regulations to interpretation. Like, for example, you were talking that crowdfunding platforms were not subject to AML, the fifth directive, right? Or the fourth, like to the AML compliance requirements. But in Spain, in the last draft of the transposition of the fifth directive of AML, they introduced as subjects the crowdfunding platforms. Then in the final draft, they took it away. But what I mean is that this kind of parts that can be interpreted by one of the countries, of course, it can affect. I don't know if it's anti-competitive, because maybe they can say here in Spain, for me it's better. Like, I prefer my platforms to be, more strict with this. But maybe another person says, well, call it however you want, but they are gonna go to another country because of that, no? So I think it depends.
Clear. Thank you, Javier. Johannes?
Yeah, I think it brings a kind of new competition. So when we experiencing currently, we have kind of patchwork regulation throughout Europe on crowdfunding platforms. This will of course be reduced. So we will have standardized and common principles and guidelines from ESMA how crowdfunding platforms shall be regulated. We have a common licensing requirement, and therefore competition will go up because I will be able not to only to serve clients in my home member state, but throughout the EU. On the other hand, there will be a competition of the single member states more or less against each other because they all want to have their piece of the cake. So if I for example, see that some countries have very low fees for applications, other countries have higher fees, this might be an argument to go to one or the other country. At the same time, I think this is a kind of our European community that you have the way to choose which is the best for you, and it's not always the cheapest one which is the best for you, but you have also to take into account where are your clients, what kind of label you want to have, which is just the best country for your setup, which is not necessarily the same for all crowdfunding platforms.
Thanks, Johannes. Sophia, any views on this anti-competitive subject?
Yes, well, I'm going to join Javier and Johannes on what they have said. I do believe that, for example, when the fees, for example, can be one of the main differences. Now, I don't have to add on that special topic, but regarding the competition, we will see lots of new actors, as I said. For example, I know that a lot of crowdfunding platform that comes from the US and that are quite big in the US didn't enter the market, the European market, because we had a wide range of regulation. Now they want to enter this new market because they know that if they set up a subsidiary in one country, they can passport in all the 20 plus countries. Therefore, the European crowdfunding platform will have to compete with those new actors, an Asian actor to Asian crowdfunding platform too. So it will set up a new ecosystem with a lot of offers, and we will see, competition will be quite rough.
Thanks, Sophia. Just one comment here, Karin.
Yeah.
Nara, I was remembering a webinar that the CNMV, the Spanish authority, participated like months ago. They asked what they thought that the new regulation could, how they thought the new regulation could impact in the crowdfunding platforms. And they thought that this could make that the crowdfunding platforms unite or reunite, like reduce the number of crowdfunding platforms, like bigger players, the bigger market, of course, but less players. I don't know exactly why they thought this, because I think that the regulation doesn't put some big barriers like economic ones, economic resources to submit to request for the authorization, but that was the vision of the Spanish authority, that we are going into a reduced number of crowdfunding platforms.
Yes, I'm just going to add something to Javier on what he has said. Actually, we started to see it. We started to see it in countries where there is no regulation, and you have not a lot of little crowdfunding player, but quite middle crowdfunding player. We see big ones eating the small ones. So I think that effectively there will be less crowdfunding actors, but bigger one.
Brilliant. Thank you very much for all these very interesting views. On another topic, there is a phenomenon. I wanted to know if you're sharing it locally or if you see a similar phenomenon. Lots of platforms trying to go live before November the 10th to benefit from this transition period. So, Johannes, is that something that you see happening in Germany or not really?
No, not really. So if you take a look at the German current regulation of crowdfunding platforms, then depending on what your model is, the regulation is stricter than what we will see under the crowdfunding regulation. So there are a lot of companies, I think, they are waiting for November to start their business and to have the light license requirement under the crowdfunding regulation with the benefit of passporting against the strict regulation or to structure your business in a way that you don't fall under the strict regulation. So this phenomenon of starting business now is not happening in Germany.
No, clear. Thank you. And Javier, in Spain, similar phenomenon or not really?
I think that Lemonway is the one that can say this the most because it's I'm a law firm. Of course, I'm specialized in this, and people call us, but you are the PFP, the payment service provider in Spain that provides services to 90%, 80% of the platforms. So you might know this better, no? My impression is that we didn't have this in Spain. I think that is because something that we talked like 5 minutes before starting the webinar, and is that in Spain it's already regulated the crowdfunding, so you cannot go live like this. So you need it to be authorized. So in the last year, for example, in Spain there was only in this year only one platform that was authorized, and last year 2020 two. In 2016 we had 9. So I think this is because, of course, the new regulation is coming, so it was a bit of a mess in the Spanish supervisory authority. But what I mean is that we don't have crowdfunding platforms in Spain that don't have to be regulated, but they will have to be regulated according to the new regulation. Like the scope is pretty much the same, and this is why I think I'm not seeing many like going live without the authorization. Maybe you now say just the opposite, but.
Yes, so indeed we do see that, especially in countries where there is no regulation. As said by Johannes and Javier, as it's regulated in their countries, it will take longer for them to go live. Therefore, there is no point to go live before, 1 month before the regulation enter into force. So we do see that effectively in countries where there is no regulation, where a crowdfunding platform can just go live if it has a website, and they want to have the transition period to be able to grow a bit and economically, and do the necessary investment to be a CSP. So yes, indeed, we do see that.
Brilliant. We have 10 minutes left, and I wanted to touch upon another point, which is about tokenization, virtual assets, crypto. These are topics that are more and more addressed in the crowdfunding business as such. So what does the new EU regulation say about this? Is there like any mention of these new like innovative approaches? So Javier, maybe you have views on that?
Yeah. Well, first of all, in Spain, it's possible. It's possible. That it's not that the law says it, but like we've done it to tokenize loans through a PFP. Okay, like one of our clients, which is also clients of yours, which is Adventuris, we did the first loan offering tokenized for a gaming project, really interesting, and some other platforms have done it or are doing it now, like they are offering projects now through tokenization. And with the new regulation, which is the important thing here, there is a consideration in the regulation, which is consideration 15, okay, which is really tricky. And why it's tricky? Because the English version says that something like this, that the regulation is not thought for initial coin offerings, like for doing the offerings, the crowdfunding through initial coin offerings. But then in the translations, for example, in the translation of the regulation in Spanish, and talking the other day with Johannes, he told me the same in Germany. They said they don't say initial coin offerings; they say crypto asset offering. And I don't know exactly how this works, but I suppose that the English version is like the one that was drafted, the first one. I'm not sure, but there's a main difference, because coin, like if you take cryptocurrency, the cryptocurrency or coin is like a type of crypto asset. Crypto asset is like the main category, okay? And I think that the regulation is thinking in like offering tokens which are gonna be used as a coin. But if that token represents the security, I think that it's totally possible. So we don't have the answer yet. I don't know the answer yet for that interpretation of consideration 15, but I hope, because I mean, if not, it's a step behind, that it will be possible.
Brilliant. Johannes, you want to complete what Javier said?
Yeah, so what Javier said is totally true. It's a bit misleading part of the regulation, in particular with you to the different language versions. So when I talk about an ICO, an initial coin offering, then I think of what happened some years ago with utility tokens. And when I say utility token, yeah, that's not a security, and this is utility, so it doesn't fall under the regulation, of course. On the other hand, if I issue a security token, then this is it's either a security, depending on the regulator's view, or it's a loan, or it's both. BaFin has a very strict view that they say if you tokenize a loan, then this becomes a transferable security under MiFID. So from this point of view, you are of course able to also use securities which are security tokens under the under the crowdfunding regulation from a German perspective.
Yeah, great, thanks, Sophia. I mean, Lemonway is already servicing or approaching, this tokenization matter. So anything you want to add here?
No, well, actually, I think that Javier and Johannes are completely right. Yes, indeed, we do service those security tokens already. The only thing is that crowdfunding platform will have to be very careful when it comes to the tokenization of such loan or else, and they will have to be able to challenge the regulator to say if they want to, if they fall within the scope of this regulation or not. And again, it depends on the regulator and on the national laws or the national interpretation of what it is, a tokenized and the associated active.
And there's another thing regarding tokenization or crypto issues here, and is that it's also possible to pay, to make the investment, an investor pay the investment, and with crypto. In Spain, we have a client, Scriptan, that he offers. One of the services is a crypto platform, and thanks to the help of Lemonway, it's implemented, I don't know in how many, but at least in 2, I think, crowdfunding platforms regulated here in Spain. We did the consultation to the Spanish authority here if this was possible. And at the beginning, I think they said yes, because they didn't understand exactly how did it work. But finally, they understood, and they said that it was fine. Of course, it has to be, you have to exchange the when you make the payment, the crypto for current coin. and then the normal process, no? But like, this is another extra crypto part that I think we will see it more and more.
Yes, indeed. I think that the regulators will have a lot of work, and there will be a lot of new setup which involve crypto assets as a whole, and which could eventually fall within the scope of this new regulation. So yeah.
You're giving me an idea for a future webinar topic. Brilliant. Thank you very much. Sophia, one question regarding, PSD2 and ECSP. You touched upon this point during your presentation. How can we connect the dots between both? And if you could just remind us about the obligations in a few words.
Yes, so basically a crowdfunding service provider, if it's not authorized as a payment service provider, should not be able to provide their payment services. Now, you can provide, if you're a crowdfunding service provider and you don't want to go with the heavy process of being a payment service provider, you can provide payment services if you are a payment agent, for example. So basically, you would be able to collect funds from the investor to transfer to the project holder if you are a payment agent registered in the home member state of the PSP that you are associated with. For example, Lemonware, we have a lot of payment agents saying that they provide their payment services through us and on our behalf, so they can collect the funds through us and transfer it. Now, if you do want to be a payment agent, you can partner with a payment service provider. However, you cannot collect funds from your investor to transfer it to a third party. This will be deemed as a payment services. So it's very important for crowdfunding service provider, if they do collect funds, if they do provide payment services, to get in touch with the payment service provider and to comply with PSD2, which is the piece of directive regulating the payment service provider.
Brilliant. And one last question before we close this super interesting session. I think it's the best way to actually conclude this session. So what is actually the main difference between before and after the enforcement date of November the 22nd, 2022? It's actually November the 10th, right, 2022?
Yes, indeed. So basically, you have 1 year for transition period. If it's not extended, and let's say that the end of this transition period will be 2022, by this end, you will have to be authorized, or you will have to have submitted your application. Now, how this transition period will work and how the regulator will regulate and deal with this transition period is something that we don't really yet know. But normally, you should have applied by the end of 2022, meaning that if you want to provide your services and your new your new platform, and you want to start to go live after the 10th of November 2021, then you will have to submit directly your application, and you cannot benefit from this transition period. So this transition period normally should apply to the existing ones.
Brilliant. So unless Johannes, Javier, you have anything to add on this, let's say, difference between before and the end of the transition period, I'm going to conclude. So anything else you want to add on your side? All clear. Thank you very much, guys. So we're coming to the end of this session. It's almost 11. A big thank to you all online for your active participation and great questions. I saw lots of questions that remained unanswered. Unfortunately, I'm going to share them offline with Sophia, and I'm sure she will take a bit of time, very kind to answer your questions via email. But I know she's very busy at the same time, so we see how we'll be able to handle that. A big thank to the three of you, Sophia, Johannes, Javier, for sharing your expertise today. Super interesting insights. Feel free to connect with our three experts on LinkedIn if you wish to pursue the conversation, of course. The replay of this session will be available after the webinar. You will receive an email notification, including the link to download the slides that Sophia presented, and we hope you found them useful. Once again, many thanks for your participation. Wishing you all the best, and very soon, hope we'll do another event online together or in person, we hope. Thank you very much, guys. Bye-bye.
Thank you. Bye.
Bye.